Marilyn Monroe, the girl who from an obscure and unhappy childhood was to become a legend. But it seems she could never reconcile her public image with the sensitive side of her personality. Perhaps her inability to live with the legend was the cause of her final tragedy.
Well, just because you've traveled to that fancy hotel in the sky and no longer have to worry about what you were and what you leave behind, no reason to believe that being part of the afterlife leaves no worries for you or those you leave behind. On the contrary. And for that, you can thank the digital age for making the lives of those caring for your estate potentially a living nightmare. Maryland's folks are finding that out. This and a whole lot more. Let's welcome to MidPoint senior trial attorney and managing member of the Pankauski law firm with more than 20 years experience at the bar, John Pankauski joins us today in studio. John, thanks for being here.
It's my pleasure, Ed.
This is an interesting case about Marilyn Monroe and her image and the digital images here that are coming in now. It's really nothing new because they've been fighting this in court for a long time, haven't they, as people start to use different images?
They have, and particularly with the estate of Marilyn Monroe, there's been a few lawsuits over the recent past, and this new one is touching on something a little bit differently. There was a New York federal case that was filed by Virtual Marilyn LLC. And they've had recent discussions with the estate of Marilyn Monroe about what they can do and what they can't do. And what they've done is they've asked the federal court for a declaration of rights. Why? Because they see the seeds of litigation ripening. And what they want to do, and the question that the court is going to have to answer is Virtual Marilyn allowed to use the image and persona of this late great actor who died over 50 years ago? And if Virtual Marilyn is permitted to do it, who else can use it? And it's really unique, and it speaks to the future, because I don't think that Marilyn Monroe ever realized when she died in 1962 that 50 years later that her image and her persona would be generating millions and millions of dollars a year. And so there's some challenges for everybody on Main Street who has property and who has an estate plan, because now people are realizing when they're planning their estate, they have to think outside the digital box, because they don't just have an IRA and cars, they have social stuff, they have internet stuff. And so the estate of Marilyn Monroe now is involved in this litigation with Virtual Marilyn LLC. And it makes all of us think, well, I may not be an actor or a celebrity, but I have pictures on my iPhone that I text you.
Pictures of your family, pictures of your kids,
Absolutely.
Pictures of your home, which is sitting there.
We text each other, we post online, we go to blogs. Some of us write blogs, some of us write commentary or a regular column. Who's going to get that, and does it ever become valuable? I mean, this needs to go all into your psyche. You've got to think outside the digital box. You don't need millions of dollars for a new social media or estate plan, but it's something to think about. Now, I'm not saying that everybody is going to have the success that Marilyn enjoyed and that their image or their persona is going to be valuable, but what if it is? How do you want to leave that, and who do you want to leave that to?
Well, not even that, but if you put up pictures of your kids, for instance, and it's a really nice picture of your kid, wonderful, nice, somebody takes that, steals it, they use it for an advertisement, they use it for something that they're pushing, or they use it for some other nefarious purpose sitting out there. So these pictures are constantly available. They are worldwide at that point.
They really are, and it makes us think, what are we doing with our digital media and our digital property? Now, clearly, if I'm an artist or I'm a photographer, I want to be compensated if you're going to use my images,
right,
or if you're going to use my artwork. But what if I text you a photograph? What if I text a lot of people a photograph or an image? Or what if I use some snappy saying in an email or a text that suddenly becomes popular? Do I own that? Do I get to make money off of that? What if you use it? What if you want to borrow it? And oh my God, you risk your money and it catches on. It goes viral and it's on a t-shirt or it's on the internet, it's in the clouds, and you start making money off of that. Do I have the ability to come in and say, stop that, or pay me for that?
Do you?
Well, that's one of the issues that the Southern District of New York, a federal court, is going to decide. Probably the third case involving the estate of Marilyn Monroe in the last few years.
But everybody needs to be aware that what you put up there can be used for any purpose. It's not private. Isn't that many times where we're going?
Yeah, I think with social media now, we're looking at rights of privacy and property rights that really didn't exist even a few years ago. And so if I'm putting things out there in the public domain, one of the concerns that we have is, am I letting everybody use it? Am I giving everybody permission to use it?
And if somebody uses it and you're not here, your estate is the one that basically has to pick up the slack and has to get involved, which makes it difficult.
Absolutely. Now, years hence, after we die, are you going to have your estate involved in lawsuits with someone you may have never met, may have never intended to benefit, creating millions and millions of dollars in revenue that you never imagined.
Hold tight right there. We'll be right back. When we come back, we're going to look at what the Supreme Court is coming up with this year and talk a little more law as well. Stay with us, because right here on MidPoint, we question everything.